Okay, great. Welcome everyone for this evening's event hosted by several community groups, including Advocates 11, Sunset Heights Association of Responsible People, or SHARP, Golden Gate Heights Neighborhood Association, Stop Crime SF, Coalition for San Francisco Neighborhoods, D2 Unite, Sunset United Neighbors, Activate SF, and my own group, SOAR. This event is the third in a series on the criminal justice system in San Francisco, and we've added a bit of extra flavor tonight. We'll drop links to the prior two events that we had in the chat so that you can watch those as well. The first was on the job of a DA. What does the role entail? And we had 5 ADA type people from around California come present on that. The second was an education on restorative justice, and we had Laura Bazelon from USF, we had someone from the DA's office, and then we had a couple of people who were sort of involved in the system in other ways. And we've rolled with the punches for this evening. So things are a little different than originally planned. And I think it's going to be an informative and engaging evening, especially since I've now had the chance to chat with Danielle Diebler for a few minutes, and she's amazing. So first up on our agenda is Danielle from the League of Women Voters, presenting the pros and cons on 2 upcoming ballot propositions. Prop C, known as recall reform, and Prop H, which some of you may know as the DA recall proposition. The League of Women Voters has a great reputation for providing nonpartisan pros and cons to educate voters, and we are extremely grateful to have Danielle with us this evening. So thank you, Danielle, and you may just take it away.
Excellent. So thank you so much for having me. I really appreciate it. I'd love to see a group this large, right, that's engaged and interested in their communities. That always makes me very happy. So I'm going to cover, just so everybody understands, the League is a nonpartisan organization. We provide the pros and the cons, not opinions. And so I want to be very clear. I run voter services, which is the totally 100% nonpartisan part of the League. We do sometimes take positions on particular propositions or ballot measures, and that's done by our advocacy team. We don't cross the streams, right? Advocacy and voter services, really, we might work together on things, but they are the voice of the League when it comes to endorsing something. I am not. I am here's the pro, here's the con, here's the data, but not the opinion necessarily. So I want to be very clear on that when in terms of things like questions or, that kind of thing. I'm going to be very, very non-committal, right?
Thank
So
you.
my group does like voter registration, voter turnout, voter education. Those are the types of things that my part of the League does. And then I'm going to drop right into, now I've given you a little bit of background, I'm going to drop right into Prop C. And so Prop C is a local ballot initiative. It is recall timelines and vacancy appointments. So it's an amendment to the city charter. And the real question is, shall the city amend the charter to change the recall process by prohibiting—
You're looking at me.
Sorry?
Sorry, I think someone just was accidentally unmuted.
Oh, okay, that's fine. So shall the city amend the charter to to change the recall process by prohibiting starting a recall before an official has served 12 months in office, right? So that's like point 1. Also, to change the recall process to prohibit starting a recall when an official has had less than 12 months in office until the next scheduled election for that office. And then also to change the recall vacancy appointment process to prohibit an interim officer appointed to a vacancy created by a recall from running for that vacant seat in the following election. So that one's a big one, right? It's a big change. So the idea is if you got appointed to the office when a recall vacancy appointment happened, you would actually not be able to run in the next election cycle as essentially an incumbent, right? You would have to wait until the next election cycle after that to be able to run. So the background on this is, under the current law, a recall is started by gathering signatures from eligible voters, right? So no person may start a recall if the official has had less than 6 months in office right now, or less than 6 months before the next scheduled election for their seat. So this changes those parameters to be 12 months instead of 6 months on both sides, right? So far in 2022, we had a budget of $12 million has actually been requested to recall 3 members of the school board plus the district attorney, right, which is the one that's coming up in June. So that budget wasn't actually set in advance. You can't anticipate recall elections. So this is an additional $12 million that we're essentially going to spend based on these recalls. The funding came out of the city budget. And for this period of time, the school board was responsible for a large percentage of the funds before the city voted to cover the entire cost of the recall. So about 70% of voters cast ballots in favor of the recall school board election, but it actually represented about 36% of eligible voters in San Francisco. So it was actually not a high turnout election, right? But the people who did turn out in favor essentially of the recall. Under the current law, there are also no restrictions on appointed officers running in any other local elections, right? So this amendment, if it was passed, it would make appointees to vacancies from recalls the only interim officers who could not run in the next election, right? So interim officers that are appointed by the mayor or the board of supervisors in the case of a vacancy of the mayor's position, right? So the board of supervisors would, if the mayor was vacate her position, they would elect or they would put an interim mayor in place. They're more likely to be elected because they have name recognition, right? If you get appointed into that office, if you're an interim officer, you just get there's no doubting that you get a little bit more of a news cycle right from that. It's easier to access campaign finance, and generally voters have to decide whether to kind of like fire them before they consider the other candidates. So mayoral appointees that have helped the diversity of San Francisco government officials because of the prior current board, over half of them are African American, Latino, Asian American, female supervisors. A lot of those people were actually appointed before they were elected. So that is something to consider, right, when you're thinking about changing the way that things are today, right, versus change or versus what the proposal is, essentially being 12 months and this big issue where they can't run again, right, as an incumbent for the same position. And they can't really run for local office. So it's a charter amendment. It would change the local San Francisco recall process overall. So it would prevent voters from starting a recall petition before an officer has served 12 months in that position, or if the officer has less than 12 months left before the next scheduled election for that office. So it changes the timelines a little bit. And I think that just so you understand the background on this, a little bit of it is just so that the Department of Elections isn't constantly dealing with 2 or 3 or 4 recalls, right? So in the last year, in California at least, and what we have felt in San Francisco is we've had 3 recall elections. We've had the school board, we've had Governor Newsom, and now we've had the DA, right? So it's a lot of extra elections that we're having to administer, right, with the Department of Elections. So in addition, this charter amendment would prohibit interim officers appointed to a vacancy created through a recall election from running for that vacant seat in the following election. So this would apply for all recalls, including the recall for the district attorney. So if you vote yes on this, it impacts actually Proposition H as well, which we're going to talk about a little bit later on. It would apply in the Proposition H perspective as well. If we look at the controller statement, so from the controller, they basically say if the proposed amendment was to be approved by the voters, it would result in actually a moderate savings in the cost of government over time. And that kind of makes sense, right? Talking about earlier, hey, it basically costs us around $12 million to run some of these recall elections. It is a process, right, where we have to inform voters, you have to have the ability for people to vote, polling stations, poll workers, all of those things that are actually amazing, democratic tools for people. But they also do cost money to make sure that those things happen, right? And that the entire city is able to vote in an election. And it would likely decrease the number of special elections that would be required in San Francisco in a given year. And that's because it actually is increasing the time, right? It's saying someone has to be in office for 12 months or has to be at least 12 months away from the next election in order for a recall to happen. So it basically says it's not 6 months anymore, it's 12. So that would decrease overall the number of special elections that we would be able to have. So a yes vote, you want to change the recall process and the process for vacancies, right, that are created by a recall. If you vote no, you don't want to make the change, right? You don't like this proposal. You don't want to move forward with it. In terms of like arguments, a combination of paid arguments and unpaid arguments that are coming to the Department of Elections, people who are in favor of Prop C say restricting interim officers from running in subsequent elections could stop the mayor from using appointments to influence elections by making their choice more likely to be elected. They also say that shortening the time frame for starting a recall could stop wealthy donors and individuals in the political minority from starting unnecessary recalls that support their own personal agenda. People who are against Prop C, they talk about further restricting recall timelines. It could prevent voters from having enough time to organize grassroots efforts like the school board recall. Restricting interim officers who are appointed to fill recall vacancies from running in the next election, especially when this rule would not apply to other interim officers, right, that were appointed. It could create kind of an unfair exception where there isn't really a need for one. And then shortening the time frame for starting recalls could allow essentially failed politicians to stay in office for longer, right? That's an argument kind of against it. And that's the basics in terms of the pros and cons. So I'm happy to answer specific questions if people have them on Prop C.
So thank you so much. That's so much information.
I know it's so much, and I hate it's so hard to like. Sometimes these things are so hard. You read through the legal text and you're just like, oh my God, how am I going to explain this to people?
Right.
Right.
I do not envy you. And thank you so much for doing this for us. And for anybody who missed it at the beginning, like this is hot off the press. The League of Women Voters just put this together like last night.
Yep.
Or over the last couple of weeks, but they finalized it. And so we're hearing it first. You're getting it here first. So yay. There are some questions in the chat.
Okay.
A couple were sent to me personally. Others might have been sent directly to some of the people who are doing logistics for us. So jump in if anyone else has questions that were sent to them directly. And also please feel free to raise your hand and ask a question. The first question in here is, are there similar regulations at the state level? And if so, how do they compare?
So there's actually various legislation that is actually trying to streamline kind of the recall process at the state level. I would say that I see that it's not on the ballot right now, right? So we're a little bit ahead of everybody else. There is some state legislation that probably will be on the November ballot that is looking at what I would call recall reform, right? Trying to figure out how to streamline the recall process so it's a little bit more fair and a little bit more equitable to kind of, both sides. But there is not currently the state guidelines actually very closely mirror what our current local guidelines are, right? There's just efforts that are going on at the state level. They just aren't quite as far along, I think, as the San Francisco recall timeline and vacancy appointment amendment is.
Okay. Thank you. Let's see. The next question in here. Who is the sponsor of this proposition?
Give me 1 second on that. Actually, I do have information on. It came from the Board of Supervisors, I think, because it's a charter amendment, but I don't know exactly who. So I'm sorry about that. I don't have it immediately.
That's okay. I believe Peskin was the one who put it who originally proposed it. I could be wrong about that though. So
I think you might be right about that. I know he's at least on it, so just give me. I know who all the supervisors are. I just don't. I did
It's
not.
figures.
Unfortunately, I did not open that. I did not open that document right before I joined here.
did someone have an answer for us? I think someone was jumping, or maybe they just didn't have their, maybe they just were unmuted for some other reason.
Marie, I can look it up. I know where it is on the website. I can look it up while we're talking and put it in the chat for you.
Okay, great.
That would be awesome. Thank you so much. We do have some.
Thank you, Peter. There's no reason for all of us to sit and watch Dan.
And yeah, and to watch me try to actually, like search my Google Drive, right?
So let's see, the next question, actually we'll go to a live question. Patrick, you have a question, Patrick Wolf.
Hi, thank you very much. So I want to make a shameless plug. My group, the group that I had, Families for San Francisco, put together a report. We published it last month. I'm going to drop it in the chat right now. And it has some really great data. I actually spent several hours in the library. I recommend this to everybody. If you actually want to learn about San Francisco politics and the history of San Francisco, we have a great library and we have some great information there. And so I can tell you, for example, people often, and full disclosure, we've come out against Proposition C, so you should know that. But people often think, for example, that recalls exploit low turnout. It's not true. In fact, there was an academic study done of recalls across the US several years ago. It showed there's actually no difference. In fact, slightly better in general elections versus special elections. You should know that San Francisco has the recall. We've had the recall since 1907, and it was part of a progressive set of reforms in order to give people more power to hold politicians accountable. And in San Francisco, we've had a grand total of 6 recall elections since 1907. So this notion that we're somehow like being buried by recalls is just completely false. And in fact, before the recall of the school board members in earlier this year, the previous recall attempt was 1983, Mayor Dianne Feinstein, which failed overwhelmingly. Before that was 1946, the recall attempt of Mayor Roger Lapham, which failed also. So, I mean, the notion that somehow we're drowning in recalls is totally false. And then the last thing I'll bring up, which I think is very interesting, is the recall's actually been amended twice in San Francisco, first in 1983, and then in 2008, both times to make recalls harder. In 1983, it was because people were really frustrated by the recall attempt of Dianne Feinstein, was sort of broadly viewed as sort of a misuse of the recall, which I think actually is very reasonable. But in 2008, when Aaron Peskin was on the Board of Supervisors, surprise, surprise, the Board of Supervisors put on the on the ballot a charter amendment to make recalls harder for just the Board of Supervisors. And the reason for that is because there were several attempts to recall members of the Board of Supervisors. None of them qualified for the ballot, by the way. But the sitting members of the Board of Supervisors were so unhappy about the idea that there was a possibility that there might be a recall that they actually put a provision on it. And we talk about it, and it's very interesting. It got like no attention. It was like during 2008 when the world was collapsing. And so, voters voted for it. It's very unlikely people even understood what was going on. But some great information in the report. Shameless plug. Thank you very much for allowing me to talk about the work we did.
Sure, just drop that in the chat. Thank you.
Yes, absolutely.
And Peter, you can jump in if you have the answer to that other question. But I will also go ahead. The next question we have in here, Danielle, is if an elected official does something that should have them removed, criminal, unethical, etc., how could they be removed if it's less than 12 months?
So there are other mechanisms. They would not have to be recalled, right? If there were criminal charges, or they had an ethics violation, right? San Francisco has an ethics commission. If there were charges brought against them, especially criminal charges, there are other mechanisms. A recall is not required to remove them.
Okay, thank you. We have a question here. You suggested that Prop C would impact Prop H. So if the voters approve Prop C and approve H, what would be the impact?
So if you approve C, right, and you approve H, the bottom line is this amendment, it applies for all recalls, and that includes the current recall of the district attorney. So if you voted yes on this, it would impact the ability for, say, the current DA to run, right, again for an office, right? There would be an impact, right? These rules apply for this current election, and that's actually kind of rare for us. I want to be clear. Like, it usually when we vote for something, it doesn't impact it. It does sometimes, but it rarely impacts something else that's on the ballot, right? And in this case, it would, right? This amendment would apply for all recalls, and it would include the current recall that we're voting on, which is Proposition H.
And that would mean that whoever the mayor appointed, if the DA were recalled, whoever the mayor appointed would not then be able to run.
Exactly. That's it. So that's the point. You recall, the current DA, somebody gets appointed into that position, and then they're not going to necessarily be able to run in the next election because this recall reform would apply to the next election cycle.
Got it. Okay, great. Thank you.
Hey, Marie.
Go ahead. Yes. Yes.
Sorry, the original sponsors were Peskin, Walton, Ronan, and Preston.
Peskin, Walton, Ronan, and Preston. Okay.
Yeah, and then looks like there were 2 votes, one on the 8th and one on the 15th. And one on the 15th looks like Mandelman, Melgar, Safai, and Stefani were no's, and the rest were ayes. That's
Okay.
what it says in the
That's
legal
what put it on
text.
the
I'll copy and paste a link in the chat for everyone to look through it if they would like.
Great. Thank you. Should we move on to, excuse me, Prop H? Unless there's another last question on Prop C, or you can still ask questions on Prop C. We won't
Hold it against you, right?
hold it against you if you didn't get in on time. But Danielle, would you like to move to Prop H?
Yep, that's totally fine with me. And Prop H is pretty straightforward, right? So, I mean, you're either voting to, at the core level, you're voting to recall the DA, or you're not voting to recall the DA. A little bit of background on this, right? There were actually 2 efforts to recall the DA that were initiated in 2021. In the second effort, there were enough valid signatures that were actually submitted to put the recall on the ballot. So the first effort was organized by a group called the Committee Supporting the Recall of District Attorney Chesa Boudin. It was approved for circulation, but they fell short in terms of the signatures that were gathered, valid signatures that were gathered to put it on the ballot. But the second effort was successful. That started in kind of I guess maybe the first or second quarter. So I think it was around April of 2021. And that was a group called San Franciscans for Public Safety. They had until the late October timeframe to gather essentially the same number of signatures as the previous group. And they were able to gather enough signatures that Director Arndt actually announced that they had enough valid signatures to put the recall on the ballot. So, and supporters basically said they don't like Boudin's approach to how he's dealing with crime. It's led to increased crime rates. They're just not happy with how he's kind of running the city and running specifically the DA's office. And I'm not going to make any comment on that, right? But the framing is very much that he's a conservative. He's being framed as a conservative that's kind of, power grabbing in terms of the people who are trying to kind of get him pulled out. I'm sorry, Boudin. I'm not used to talking about this one as much, right? So I'm reading for my talking points, and then I'm like, oh, these are in the wrong order. So I am very sorry.
Okay.
So
What?
Yes, the people who are kind of leading this effort are being framed as conservatives. The Boudin is being framed very much as a progressive, but a progressive that doesn't belong in the DA's office, right? That's what people are saying. He's not criminal justice reform. Yeah, it doesn't start necessarily in that particular office. He's our he's our person that should be putting people away versus our person who should be trying to reform the criminal justice system. And I think that depends on what side you're coming from, right? Whether you agree with that or not. This is not the controller doesn't have this is not going to cost us a huge amount of money because we'll essentially appoint someone that's new. All of the dollars from this come from the fact that we did a recall to start with, right? It's the fiscal impact is really that.
Okay.
And there are not a lot of, so normally we try really hard to, like with pro-con arguments, like the people who are for and against, to kind of try to not be on one side or the other. I have to be honest, the arguments here are very partisan.
Okay.
So the people who are opponents, right, are very focused on the idea of this is a Republican initiated effort that will cost taxpayers millions of dollars. Voters elected this person, right, to reform the legal system. He's doing his job. And then the other side of it, which is, if you're against it, right, you're basically saying it's false and disproven. The talking points are, highly partisan, highly Republican. Voters selected this person, keep this person in office. So it is a little bit of a hot button. I want to be honest with you, right? In terms of whether you do recall or you don't. But if you're looking at purely from the pro and con perspective, it's either you want this person to stay in office or you don't want this person to stay in office, right? And you essentially have to make a decision kind of based on that, right? And knowing that it got on the ballot because people signed something, right? They signed a petition, enough people signed up for it, and enough of those signatures were valid that the Department of Elections said, you know what? They got their 83,000 signatures submitted by the deadline. They got validated, and that it's showing up on the ballot because of that.
Well, Danielle, I really appreciate you highlighting for us that it's a hot button issue because I hadn't noticed.
I know. Every time somebody asks me to talk about it, I'm like, no, please. This is not this is so hard to do a pro con on because it is very controversial. People are very passionate about this, and one play or the other, right?
Yes. Well, that's why after this piece is wrapped up, we're going to move on to what we sort of had originally conceived of for tonight was a debate between either Chesa or one of his people on his campaign and someone from the recall campaign, and so we'll move on to it's not quite going to be exactly that now, but we're going to move on to that next, so you don't have to feel responsible.
That one I probably will bow out on, just to be honest with you, because it's not really being involved in a debate about whether we should recall the DA is definitely not my place, right?
Yes. And I so appreciate that the league is nonpartisan and able to come and present both sides to us. That's really helpful. There are a few questions in the chat, and I also see there's a hand raised. So why don't we go ahead and Frank, you have your hand raised. Why don't you go ahead and ask a question, and then I'll tee up a couple of questions in the chat.
Sure. I didn't hear a lot of arguments in support of the recall. I heard the arguments loud and clear about why people are opposing the recall. But one argument I'm hearing is that many people have died or been assaulted by people who were released by the District Attorney's Office under Chesa Boudin. Hanako Abe was, of course, murdered, and Elizabeth Plott was murdered by someone who had been released with no additional jail time, by the way, by District Attorney Boudin. Have you heard that argument? There was a list of 11 people who had been assaulted or killed. That was about 8 months ago, so it may be larger now. Danielle?
So I think we have seen that, and we've also seen just kind of that fits into a larger argument, right? So that even essentially progressive prosecutors feel like it's the office is being underserved, right? They're not prosecuting the right crimes. And essentially, I mean, ultimately, it's that he's not upholding his duty to protect public safety, right? And there are some stats that have been quoted in that. The problem that you have a lot of times with the stats is they don't necessarily get associated with the actual measure. So when we look at, say, like arguments that are for and against, they may or may not have been submitted. So in a news article, especially when it's a single news article, if we can't verify it via a third-party source, we sometimes won't use that as a single note, right? It doesn't mean the public can't use it as a piece of information, but the league itself is unlikely to use information that's only verified by a single source.
Okay, great. I have a question in here that sort of refers back to Prop C.
Okay.
If the appointed interim office holder cannot run as the incumbent in the next election, so if someone's appointed in June, they can't run in November, can they run in the election after that? So
Yes. Yes. Yeah, they can run in the next election after that. They just can't run in the next election after the appointment period essentially ends, right? So the one that essentially is just the next one over.
Okay. And then once a proposition to recall someone qualifies for an election, how is the timing of the election determined? School board recall was a special election. DA recall dovetails with the June primary. That's all part of the question?
So it's based on the number, it's essentially based on the number of days till the next election. So the Department of Election and the city charter, but it's primarily DOE and election commission rules tell them that essentially they have to run the election within a certain period of time. So if it happens to dovetail into an election, awesome, right? They can just pop that on the ballot. Maybe there's a little bit more work they have to do because now there's a new ballot proposition, which is what recalls typically end up being. But if not, they have to run a special election.
Marie, it says in the recall procedures that it has to be between 88 and 125 days from the time it qualifies.
Exactly. Yeah. So
they look to see whether there's another election coming up, whether they have to do a special election, the cost associated with doing a special election, and they determine when the best timing is for that, as long as it's between that 88 to 125 day time frame. Danielle, forgive me for jumping in there.
No, that's fine. If you have that readily available, I know I was going to say it's usually within around 90 to 180 days, right? So 88 to 180 is pretty good, right? but it is typically DOE has some ability, right, to do that based on an upcoming election or what they think is kind of the best outcome for voters.
Great. The next question in here is, what about it being that we wanted a progressive DA who would improve how the office was run in fairness and efficiency, but did not want lawlessness? And I'm not sure that's a question you can answer.
I don't think I can answer that question. I'm not sure I 100% understand it, right? Either. I think that at the end of the day,
you really an idiot.
You really have two people, right? You have two sides here. One is people feel like, the DA is too lawless. Other people feel like he's doing the right thing, right? And that's really what it comes down to.
Right. Okay. Let's see. Jorge, you have your hand raised. Do you want to jump in?
Yeah. Yes, I do. Yeah. This is not a question, but it's a comment. I recently I voted to recall for the recall, but I recently saw an interview with Boudin, and I can't remember exactly what local newspaper was for it, but it was about a 1 hour interview. And he said that he blames a lot of the, first of all, he claims that the statistics are in his favor about, not being soft on crime, but he claims that as a city, we are not very good about reporting crimes. And he also blamed a lot of the judges in terms of being too lenient with some of these, some of the sort of the arrests and things like that. So I thought, to some effect, to some extent, I kind of was starting to change my mind about, whether this is a right thing to do or to let him stay in office for 4 years, whatever. The one thing I did not like was how aggressive he was towards the interviewer. And I'm thinking that in a position such as so important as he has, the spirit of negotiating and coming up with reasonable outcomes, I felt that he was extremely aggressive about his position. I can understand that he's feeling threatened or personally assaulted by the city, but I just felt very uncomfortable with his demeanor towards the interviewer. That's all I have to say.
Okay.
So I can't comment on that. What I can comment back on is, because that's very much an opinion, right, that you're giving me. What I can do is I'll share a link in the chat. So if you look at votersedge.org, this is a nonpartisan independent site. You can get information on who supports or opposes this measure, right? So people who've endorsed it, people who've essentially put money into the recall versus people who potentially are now saying, no, we don't want you to recall. And you can see that, like, I don't know, just a few organizations, right? So people who are no on Proposition H are the ACLU of Northern California, the American Federation of Teachers, Bernal Heights Democratic Club, California Nurses Association. People who are yes on this proposition are, and I don't know who these well, I know who the ACLU is. I'd have to be kind of in who the American Federation of Teachers is, right? But some of these organizations, I don't know who they are. The San Francisco Republican Party is a yes. The San Francisco Taxpayers Association is a yes. The Coalition to Grow San Francisco, Grow SF, they're a yes. So take a look at, who's endorsing it and read the endorsements, is what I would encourage you to do, to see, are these people whose company you want to be in, right? Versus the other side of it, where they're, the yes versus the no. And it also helps you understand, this site also helps you understand a little bit more, where's the funding coming from? Because I know that there was some controversy during the school board election where people were really worried about funding coming from outside of San Francisco to push forward the school board election or the school board recall. And I think that there's a little bit more transparency in terms of the funding for the DA recall at this point.
Yes, thank you. I think there's one more question in the chat that's worth asking, and then one person has his hand raised. The other things in the chat I don't think are really your purview.
Okay.
We are moving to something else when we wrap up with your presentation, so those can be part of that. But the one, well, actually, I guess this might not be your purview either. Any comments on how last night's results could predict the results of the DA recall? Is that
sorry, I don't know what last night's results are.
Oh, Haney winning.
Oh God, I forgot yesterday was the 19th. I'm so sorry. I've been so caught up in redistricting, actually, that I don't live in AD 17.
Yeah.
So, other than social media and some hey, vote, right? I'm not as so I don't have any comments on that. We don't comment on specific candidates ever.
Okay.
So that's just not our purview.
Thank you. And Larry, do you have an appropriate question? Why don't you jump on in and we can figure it out?
No, not appropriate for the League of Women Voters. No, she's non-biased, and that's perfectly fine. So I'll hold off.
Okay, good.
Yep. I'm happy for you guys to be biased when I'm not here. How about that?
Right. There we go. Perfect. Well, this has been absolutely fantastic. Thank you so much, Danielle, for providing us with just a unbiased overview of what these two propositions are about. We might actually ask you to come back and present on the other propositions in the next few weeks if you would be willing to make the time for us.
Yep.
But I'm glad we got you right off the press.
Well, I'm sorry that I maybe wasn't as polished, right, as I could have been if it was not right hot off the presses, but I did my best. So hopefully I answered most of the questions that you had. And it seems like you've got some good policy wonks out there, right, in your team. So they were able to fill in the individual details where I wasn't able to recall them off the top of my head. So thank you.
Thank you so much. Well, it wasn't even the team. It was just people who were attending the event. So
Yep.
it's great that we have a really wonderful engaged citizenry. So
Yep.
thank you so much, Danielle.
And I expect everyone here on this call is definitely going to vote in the next upcoming election. So I like that.
Yes. Right.
Awesome. Thank you guys so much. Have a wonderful rest of your evening. And I hope that you have a lively and fiery debate.
I think we might.
Thank you so much.
For that.
Right.
Thank you, Danielle.
Thank you.
Yeah. Bye-bye. Thanks.
All right, everybody. So if we can get our debate, well, first I'll just introduce quickly Frank Noto from Sharp. Did you want to say anything before we jump into what we're calling a debate, but is really kind of going to be something else now?
So I just want to point out that the groups who organized this made a very strong effort to include both sides, and I'll let Marie talk about that on her side. But our organization, Sharp, the Sunset Heights Association, which is a group of residents in the inner Sunset, one of our members ran into Mr. Boudin last weekend, and Mr. Boudin said he'd be very happy to come and speak to us. So we immediately sent him an email and sent an email to his communications director and invited him, and we got nothing. I called his office and got no response. And so to date, we've gotten no response from his office, despite the fact that he said, yes, he was very interested in coming to meet with us. But we're very happy to have Brooke Jenkins from the pro recall side come and speak to us.
Thank you, Frank. And yes, I will just add a little more color to that. SOAR started planning this event and inviting other community organizations to be involved well over a month ago. And we reached out, our program team reached out to Chesa directly, to the DA's office, to his campaign, the anti-recall campaign. On multiple occasions. At one point we did get a yes, and then it was changed a couple of days later to a no, they're not going to participate, when we explained the format was going to be a debate. So it's very unfortunate. I mean, I will say up until this afternoon, we were sending emails saying, we welcome your participation. We invite you to come. We hope you will come. Whether it's you or a representative, it's important to us that we have both sides represented. So, and now here we are. And unless there's someone out there who I don't realize has shown up to represent the no on the recall team, and if you have, raise your hand now. Then we are going to move forward with a conversation with Brooke Jenkins, who is here representing Yes on the recall. And we have I think an empty seat as far as I can tell for Chesa. But again, if he wanted to jump in right now, he's more than welcome to. And in that case, we will move forward, and proceed with Brooke, and hopefully have a rich conversation while also trying to represent what we think the other side might be. I personally watched a bunch of videos of conversations Chesa has recently had, or interviews or presentations that he's given. So I am hopeful that that we will be able to sort of articulate what his side is on things, and have a good conversation with Brooke. Brooke, would you like to introduce yourself? You might not need introduction at this point, but please go ahead and introduce yourself and we'll get started.
Thank you, Marie. And yes, for anyone that isn't familiar with me yet, I am Brooke Jenkins. I spent the last 7 years up until this past October in the San Francisco DA's office. I was hired by George Gascon. And of course, Chesa took over in 2020. I, like anyone else who's come to the DA's office with no criminal law experience, started in the misdemeanor unit, worked my way up to general felonies, which is the unit that covers robberies, burglaries, sort of your regular type of assaults, gun possession, drug sales. I was also simultaneously the hate crimes prosecutor for almost 2 of the years that I was in that assignment. I then was promoted to the sexual assault unit by George Gascon. And then after Chesa took over, he promoted me to the homicide unit, where I spent the next 1.5 years up until my resignation. One thing that I like to share is that at the time that Chesa began campaigning, I had not taken a position intentionally to support any of the candidates. Not knowing what the outcome would be, didn't want any of them to feel as though I had opposed any of them. I wanted what was best for the San Francisco DA's office and what was best for San Francisco. And I would have supported whoever was elected. I knew Chesa Boudin as a public defender. We had a number of cases together. We had been friendly to one another throughout the course of having cases together. And he actually was the only candidate that reached out to me during the campaign, despite the fact that I knew 3 of the 4. And so I agreed to meet with him when he reached out to me. We met at a coffee shop on 7th Street, right near the Hall of Justice. And I spent an hour talking to him about my thoughts of what changes we needed in the office. He asked me a number of questions about how what I thought about what was needed in the DA's office. And also he asked me how to build trust with the attorneys who he felt were skeptical of his campaign. And so we discussed that. And one of the things that we discussed was a fear that many attorneys had about him potentially firing many of us. And so he assured me at that time that was not in his plan. He wanted me to take that message back to the office, which I tried to do. And so from the start, I tried to be supportive of Chesa because if he had, believing if he had won, I still wanted him to be successful in the job because that's what was best for San Francisco and the office. Should he have won. And so I want to start by saying that because I want everybody to understand that I did not enter this from a position of skepticism or even just being against him from the start. I wanted him to succeed at the time that he was elected. But what I quickly noticed was that on day 1, when he fired 7 of our most experienced prosecutors, including 4 managers, one of whom was the only African-American manager in the office, a Latina manager, I did have grave concerns at that point right away, because that was not in line with what he had expressed to me during that meeting. And we lost a vast amount of experience in the office that day and leadership that we needed. And so from that point forward, I tried to simply continue to do my job. As I said, he promoted me. I was grateful for that. Homicide was always the assignment that I desired to be in and move forward with doing my job. Many of you have probably heard me talk about the murder of my husband's cousin, which is what happened in the interim time, and the DA's office refusing to charge that case under Chesa's position that he won't use gang charges under any circumstance whatsoever. And so, that was another sort of point of concern for me, that we were making decisions in the office not to hold even our most violent and deadly offenders accountable where we could. But again, I tried to sort of focus on the caseload that I was assigned and move forward and ended up trying a case involving a very heinous murder, and secured a guilty verdict in that case. We moved forward from that point to the second phase of the trial, where the defendant had the responsibility to prove that he was insane at the time of the murder, because he had entered a plea of insanity. That played out where just Chesa and I had a little bit of back and forth about whether or not I should even move forward with that phase of the trial. I told him I believed we should. The jury ended up hanging on the seventh day of deliberations. It was a very long deliberations process. On the seventh day, they came back saying they weren't able to agree. They were stuck at 6-6. And we sent them back to continue deliberating. And on the eighth day, they came into the courtroom and said, we are not going to be able to agree. And they were stuck at 7-5. One juror had switched to insanity at that time. Expecting that they were going to hang based on the 6-6 note, I made an agreement with the defense lawyer, who was a public defender, that we would allow the judge to render a decision on the issue if the jury couldn't agree. She entered into that agreement. When the jury hung, we decided that we would move forward with that agreement the following day, only to have her send an email to Chesa and myself outlining why she wanted Chesa to simply override that agreement and instruct me to agree that the defendant was insane. And that is essentially what happened. By the next morning, I received word from my supervisor that Chesa was instructing me to agree to the defendant's insanity. What I want to be clear about, since we have more time than what I'm given in a general sort of news media interview, is that my main concern in that case was the fact that the way in which Chesa went about the decision was reckless. He did not request to meet with me or have any meaningful discussion with me about the case, about the 7-week trial I had just completed, and what evidence and testimony had come forth during those 7 weeks. He didn't review any part of the case file. He didn't request to read any of the 4 expert reports, which were drafted by experts who had interviewed the defendant and had made an assessment of him. He didn't ever avail himself of the ability to watch that trial. And so he was making a decision that had a significant impact on public safety here in San Francisco, based simply on an email from a public defender who actually was more than just his former colleague, but his former office mate at the public defender's office. What most people don't know is that it's not a choice of prison or the mental hospital. It's not as simple as that. When someone is deemed insane, they have the right within 1 year to petition for their release if a judge determines that their sanity has returned. And so this decision put at risk a very dangerous individual being placed back into our community within 1 year, which is now just a few months from now, without any sort of ability, or he had the ability, but he didn't have any interest in making an educated decision. And so it was that was the final straw for me, that I could not continue to pursue justice in these cases and have the leadership in the office be willing to intervene in that fashion and put the public at risk. But rather that I needed to leave, and ultimately decided that I would speak out in favor of the recall.
Thank you. I have heard that story before, but definitely did not have all of the context and detail that you were just able to provide. So that's very helpful. Why don't we take a step back and talk a little bit? Can you talk a little bit about, there are so many different players in the criminal justice system. You've got the police department, judges, public defenders, prosecutors. Can you give us just a quick overview of their specific roles, and then talk about, well, first, can you just give us an overview of their specific roles?
Yes, and so many of us have probably watched the show Law and Order, and in the intro that talks about how the police are who make the arrests and the district attorney's office is who prosecutes the offenders. Well, that's exactly the way it works. The police, of course, as you know, are on the street and they make arrests, they conduct investigations. When they make an arrest, they not only, of course, draft a report, they collect all of the necessary evidence, and they actually book the person on specific charges that they believe the person has violated. They then take all of that and fill out a form and submit it to the district attorney's office. The district attorney's office has what is called a charging unit. It is a unit comprised of used to be a very experienced assistant district attorneys who know, exactly what they're doing. And they look at the report and the evidence, and they decide whether or not the DA's office should actually pursue those charges and file a complaint. They sometimes agree with the police, they sometimes don't. Sometimes they file charges that are different or are less, or sometimes even more serious, based on the standard of proving them beyond a reasonable doubt. That's their assessment. Once the charging unit decides to move forward with filing charges, they draft a complaint, and that complaint is filed in court. The first time a person appears in court is within 72 hours of their arrest, and they show up for what is called their arraignment. That is before a judge. They are informed of their charges. They enter a plea. Almost always that's a plea of not guilty. And then there is generally a large discussion about whether or not they should remain in custody. Generally on misdemeanors, people often are out of custody when they appear. They're cited to come back to court. But in felony cases, more often than not, they come into court in custody from the jail. And so the judge is who ultimately renders the final decision about their custody status while the case is pending. There is subsequently a preliminary hearing that judge or some other judge will hear for the DA's office to prove that there's probable cause to believe that the person committed the crimes they've been charged with. That's to ensure that we're not filing frivolous charges and then keeping people in custody unnecessarily for months or years. And then you move forward from there if the judge believes that there's probable cause towards trial, and the defendant has their right to invoke their right to trial at that point, and you get assigned to a trial judge when it's your time to hear the case.
And in San Francisco right now, is crime down?
So there's been a lot of discussion about that. And unfortunately, what I've learned through this process is that data is hard to come by. Not only is the data that is compiled and kept by the police department doesn't seem to be consistent, but the DA's office has not been as forthcoming with the data that it has, which has made it very difficult. I've seen, the Chronicle make reports about crime levels being down in certain categories. I've seen other news agencies report that crime is up. What it appears is that there are certain categories of crime that are on the rise and that have risen in particularly the end of 2021, which are certain types of burglaries, assaults, and I believe 2021 did surpass the number of murders than there were in 2020. But there are certain categories that are up despite the fact that certain others are not.
And I would, of course, like to ask Chesa the same question, but we only have an empty chair for him tonight. So unfortunately, we can't ask that question because I know it is his position that crime is down. One of the things that we do hear most often is the confusion around the crime statistics. I was just watching an interview earlier today where Boudin was saying that crime is down. He's charging. He specifically said in this particular interview that he is prosecuting more than his predecessors and then in other counties. And then he said I'm charging more than anyone else. And I'm not sure exactly what any of that means. And can you kind of tease that out for us? Because it sort of got lost in the conversation that he was having with this interviewer. And I'm wondering if you can dig in on that for us.
So yes, and so we've all probably heard a number of statements from Chesa sort of touting his prosecution rates, saying he's filing charges in more cases than his predecessors. And I think the first concern that he arose after the Troy McAllister case, when Hanako Abe and Elizabeth Platt were killed. That is the case where they were walking across the street at 2nd and Mission, and Troy McAllister was driving a stolen vehicle 60 to 70 miles per hour, high on drugs, and hit them, killing them. And it became known through the press that he had been arrested 4 times since being released. And this is a case hopefully we can discuss later on in more detail. But Chesa released him while he was pending trial on a robbery shortly after he took office. And in the next 9 months, Troy McAllister was arrested 4 times. Those cases were submitted to the DA's office here in San Francisco. And each time the DA's office declined to charge Troy McAllister in those cases. The 5th arrest that he had was for killing these 2 women. And so on December 31st of 2020, there was quite a bit of unrest and attention on the lack of charging of Troy McAllister in those 4 cases. And so we saw a big shift at the DA's office in sort of this desire now to charge in most cases. But the reason that Chesa wants to highlight, in my opinion, his charging rates is because he wants to distract you from what's being done on the back end. Charging simply is filing a charge, right? It's you can file a felony assault at the time that the person is arrested. But if you resolve that case for a misdemeanor battery, or you dismiss that case, well, then the charging doesn't really reflect the outcome of what happened to that person, or what you believe their conduct was, or the value of that conduct. And so what we are seeing is that while many cases are being charged, it's the way that they are being resolved that is much more of the concern at this point. And much of that shift in the charging initially seemed to be the result of Chesa hiring immediately one of his colleagues from the public defender's office, a 20+ year veteran public defender, to come and manage the charging unit at the district attorney's office. And so, of course, as you would expect, when you have a public defender who has no experience charging crime and has a particular mindset that they were entitled to have as a public defender, running such an important unit where you're deciding exactly who and what gets charged, that there was a decline or something going on at the time that Troy McAllister, remained out on the street despite those arrests. And I can name other situations that are similar. But they noticed after that they had to change their approach. And so the concern now is what he's doing with those cases after they are charged.
A recent Chronicle article highlighted the diversion rate has gone up 20% and his conviction rate has declined by 20%. Isn't diversion a good thing? Isn't that something that we want for our system to be a little bit more focused on restorative justice and things like that?
Yeah, and that's a very fair question. It's something that deserves attention. And so that is one of the things that I've been mentioning when I said what's happening on the back end should be more of our focus. And what we know from Chesa's own data that he supplied to the Chronicle, his diversion rates have soared, right, up by 20%. What most people don't know is there's sort of multiple tracks that you can go on to avoid prison. There's not just one. Diversion isn't the only one. When we're looking at alternatives to incarceration, We already have a set of collaborative courts, which are courts that are designed and created to address sort of those root causes of crime that Chesa talks about, that were formed by his predecessors, Kamala Harris, many of them by George Gascon. Those courts include drug court, mental health court, it's called a behavioral health court. We have veterans court, which is a court strictly for people who have, done service for this country, to access the benefits that you can as a veteran to get services. We have young adult court, which is something that was created by George Gascon for offenders who are 18 to 25. They receive a case manager. And all of these courts have a specific judge that is, so that they're only dealing with one judge. That judge gets to know them, gets to know their case. Young adult court gives them a case manager. They receive vocational training. They receive help with getting their GED if they don't have it, counseling services, a number of things to sort of get their lives back on track and in the trajectory that we all would hope that it would go. And the way those courts often work is, in order to enter them, you enter into a plea. Most often, you enter into some type of plea to a charge. And the understanding is that if you follow through and complete the program, that you will be able to then withdraw the plea to that charge and enter a plea to a less serious charge, or in some cases, earn your dismissal. Diversion is something very different. Diversion is simply, it's kind of a watered down version of that. You have to sometimes go to just some classes, be it anger management classes, Narcotics Anonymous classes, parenting classes is one of them for parental care diversion. And if you do sort of these 12 classes or how many ever they assign you, your case is dismissed. It doesn't require you to enter a plea at the outset. You just are sent there, and hopefully you complete those classes, and that's your dismissal. Historically,
and if you don't complete the classes, what happens?
Well, so that's the key here. So historically, diversion was reserved for low-level offenses. It was not a place for violent offenders or very, very chronic offenders. It was for those who, were kind of new to the system maybe, and didn't have a long criminal history. And we wanted to keep them sort of as a full citizen in society, meaning with all the abilities to do all the things that we want you to do in society. And so we gave you the opportunity to not end up with a conviction on your record, or you've committed a crime that's very, very low level. And again, want to give you the opportunity not to have that on your record. But now what we are seeing is an abuse of all of these programs, particularly of diversion. We are now seeing violent offenders being sent to diversion. Diversion is something that actually has structure and rules. You're actually not eligible for it if you've committed a violent offense. So what we're seeing happen is, and I can tell you about an example, which is of a man who committed an armed carjacking. And what happened was he was charged with felony carjacking and felony robbery, which are both serious and violent felonies. They're not eligible for diversion. But Chesa's office dismissed those charges and added new charges of grand theft, which is just your average theft of something over $950, making this person eligible for diversion, and sent the person to diversion. That is not the way that diversion should work. We are also seeing people not complete the programs, not complete classes. Because of course you are out of custody while you're going through diversion. People picking up multiple new cases and not being sort of taken out of diversion, but being allowed to remain despite now having 2, 3, 4, even 5 additional cases, clearly demonstrating that they are not willing to take advantage of this opportunity, right? And the final thing is, there's no protection in diversion for the DA's office and for the community. Chesa talked about how, in the interview with The Standard, about how, if somebody doesn't complete diversion, we can always just move forward with the criminal case later on.
Exactly.
But
Yeah.
as a prosecutor, what we are always thinking about is access to our witnesses, to our victims. And if somebody has been allowed to flounder in diversion for a year, sometimes even more, before the DA's office says that's enough, and we haven't required them to enter a plea on the front end, we are now a year or more later trying to build a case to go to court with, after so much time has passed that victims have become upset and oftentimes unwilling to move forward and help the case. Witnesses have moved away. We've lost track of their phone numbers because they've changed. It's very difficult to put together a case for a trial a year or more later, when you haven't been in touch with these people for that full length of time. And so it's very unrealistic to believe that we can just simply snap our fingers and move forward with a criminal case when we've been doing nothing with it for some long period of time. And so that's why initially we have always engaged in having the protection of having the person enter a plea at the outset, especially in the kind of more serious cases, so that we didn't have that problem. If they didn't complete the program, they already had entered their plea of guilty and they knew what sort of consequence they were facing if they didn't complete it.
So this is something that I was looking at in the standard interview myself, that he was talking about, and I'd love to ask him, but again, he's the empty chair in the corner up there. We don't have him here, so I can't ask him. But it sounded like he was saying, you know, he's pushing things into diversion. That's so much better, which of course, I think everybody wants a better outcomes from our system and for people to go on to lead productive lives, and incarceration isn't always the right answer. But it sounded like what he was saying, that, you know, people go into diversion and very quickly, if there's a problem, they take them out of diversion and they charge them with the original crime. And it sounds like that's not actually really happening. And that is much easier to say, but it actually is much harder to do if you haven't charged for the crime on the front end.
Yes. And so what I've tried to explain to people is that Chesa's rhetoric depends upon the listeners not truly understanding the system, right? For the average person, you would say, yeah, absolutely. Okay, that's the safeguard. If they don't complete it, then you just move forward with the case. But as prosecutors, we know that that's actually very, very difficult and rarely ever happens when you've allowed that much time to elapse. And so what's happening is when we have compiled public records in a lot of these cases, and what we're seeing is, like I said, despite people picking up new offenses, despite people not showing up multiple times and completing these programs, they're still being given the dismissals, because diversion results in a dismissal. You complete these parenting classes, you get a dismiss, your case is dismissed. It goes away forever like it never happened. They're still being given the benefit of that outcome, despite the fact that they are failing at the program, at actually doing these classes.
And they commit another offense, then they're considered a first-time offender. Is that correct?
If they had no other record, yes. It's as though that prior case never happened.
Okay. We have a question in the chat that is relevant right now, so I'm just going to ask it to you. Can you speak to the efficacy of diversion programs where the convicted individual resides outside of San Francisco and therefore is not really participating in the support structures here?
Yeah, it of course makes it more difficult. A lot of these offenders don't have cars. Some of them don't, have phones. And it makes it very difficult if you don't live in San Francisco to access the classes that you need to go to. It's something that, every defense attorney and prosecutor should be keenly aware of, to know, are you in a position to actually succeed at what I'm setting you up to do? And so for someone who doesn't have a car, who doesn't have a job, and so therefore can't afford to ride BART in and out of the city, who doesn't have a phone where they can be sort of reminded sometimes about, hey, it's Tuesday, you're supposed to go to your class this afternoon, it makes it very, very difficult for them. And so Chesa wants you to believe that diversion is this arduous, very difficult program. It's actually not. for anyone that resides here and keeps up with what they're supposed to do. It's actually quite simple. You go to these classes and you're done. But sometimes for those who don't have the means, like I've just described, it can be an impediment to their completion. The collaborative courts that I mentioned, those are the programs that are arduous. Drug court requires you to go oftentimes to inpatient drug treatment. Mental health court requires you to agree that you will take medication for your mental health issue and to go to treatment programs. And so those are the ones that people oftentimes, it takes a lot to get to the point where they are willing to engage in that fashion. But there are safeguards. And like I said, specific DAs, specific public defenders, a specific judge who are there to sort of help them along the way when they stumble, to pick them back up and put them back on course. Diversion doesn't have those safeguards. The safeguard is if you don't do what you're supposed to, then you're not allowed this benefit. And Chesa has done away with that.
Are there any stats on diversion? And some people are mentioning in the chat, like the neighborhood courts. We had a speaker on the neighborhood courts at our March event. And it's, if I recall correctly, in the neighborhood courts, do you go into that and then they wipe clean your record and they don't really follow you? Is that?
So the neighborhood courts, I don't even think that they exist anymore, to be honest. They used to be, that was sort of an invention of trying to have community-based restorative justice, where instead of us sending you to criminal court, you sort of answer to the community. The neighborhood, right? We had community members who sat on these committees called these little courts, and they decided sort of what you needed to do to engage, and your case was not sent to the criminal court, actually. And I don't believe that those are going on anymore. This is something different and distinct. It is done through the court system. But again, it's sort of the decision on whether or not you remain in diversion is up to the district attorney's office. And we have now watered down every safeguard that we used to have to ensure that people earned the right to have that dismissal, and that we were sending the appropriate people there. People who rob somebody with a gun should not be in diversion. They should not be eligible for a dismissal for going to parenting classes. That shouldn't be the case.
Chesa ran on a platform of ending mass incarceration and reforming the system. Do you agree with those goals? Do you think a tough on crime approach would be better? Sort of, where are we now and what do we need to do?
I absolutely 100% agree with his end goals. I've expressed that from day one. The system continues to need reform. We absolutely need to continue to work towards alternatives to incarceration as our main focus. Alternatives that actually are proven to help people change the trajectory of their lives. And so I have never disagreed with Chesa on those fronts. My disagreement with Chesa has been in the execution of achieving those goals. I don't believe that sort of this soft on crime, tough on crime is sort of the right way to frame this conversation. What we are looking for, what we are calling for out of this recall is balance. Reform has to be measured. There is a way to achieve reform and maintain public safety. And that is based on the way that you execute that reform. And I'd argue that what Chesa is doing is actually not reform. To simply say, okay, you've committed, no matter how many crimes and what type, all the way up to murder, we're going to allow you back out onto the street. No consequence, no programming, no real meaningful programming, and put you back into the same circumstance that brought you into 850 Bryant Street. That's not reform. Reform is actually making sure that your attorneys are executing discretion in a proper way, right? Giving safeguards in your policies that don't allow for the disparate treatment of defendants based on race, based on gender, those types of things, age. We want to be taking an approach that is, yes, fair to the defendant, but our priority has to always remain public safety. That's the order of the district attorney's office. And I have implored people to understand that what Chesa is doing is actually putting the reform movement in danger. If people around this country in cities far less compassionate than San Francisco see what's going on here as an indication or a depiction of reform, they will outright reject it. They will maintain the broken systems that they have, right? And we want them to see San Francisco as a model like they have and embrace what we're doing so that they will engage in change where they are. And Chesa has now, right, because this is a national headline, he's putting that in jeopardy. And so that's what we are trying to protect and promote, is a balanced approach that achieves reform while keeping San Franciscans safe, because that's what we deserve. We deserve to not have to worry that somebody's going to come into our house at night.
So in the SF Standard interview, Chesa said that every day his office is in front of judges asking for incarceration, and that the judges are letting these people go, and it is not his office. His office is in there demanding incarceration, and they're not getting it. Can you speak to that? Because that sounds very different from what I think a lot of us understand to be happening.
Well, first of all, that wouldn't align with his ending of mass incarceration platform that he continues to maintain, which again, I am for alternatives to incarceration. So the two actually don't add up. But more importantly, I want to explain the fallacy in those statements. First and foremost, there's 2 points in time where assistant district attorneys are in court discussing someone's custody status. It is at arraignment, generally, when the person first comes to court, like I said, and they come in custody, and you have this debate. The other is at the time of sentencing. Well, let's start there, actually. As we all know, the majority of cases resolved by way of plea, not trial. When it's a plea agreement, the district attorney's office has negotiated what the actual outcome of the case will be. So in particular, for example, if it's a robbery case and we decide we're going to offer you 3 years of state prison, and the defense says, okay, great, I was facing 12 years. I'm going to go ahead and jump on that 3-year deal. And we go to the judge and we say, Judge, we've agreed to a plea arrangement. And the judge says, okay, what is it? We say they have to plead guilty to robbery and they will be sentenced to 3 months in prison. And the judge says, okay, let's take that plea. And then they read this long colloquy to the defendant. The defendant has to enter a plea of guilty to that charge that we've agreed upon. And then they are told that on the date of sentencing, you will be sentenced to what you agreed to, the 3 years. If that changes, actually, we will allow you to withdraw your plea, because that will nullify that deal you just made. So the judge has zero input in the outcome of sentencing, because we've agreed to it as a part of the plea. There are no surprises when somebody takes a plea. That's the whole point of it, right? If somebody goes to trial, that's a little different. If they go to trial, and which is in a very small amount of cases, the judge gets to determine what the sentence is if they're found guilty. And there are parameters for that, right? If you're charged with robbery, the maximum for robbery is 5 years if you haven't used a gun or, it caused great bodily injury to somebody. And so that the minimum is 2 and the maximum is 5. The judge can only work within that framework. But it is completely false to say that attorneys are in court begging judges to send people to prison on plea deals, because that's a part of the agreement from the outset. The judge simply approves it or doesn't approve it. When you go before that to arraignment, the way that it works, like I said, is the person enters a plea of not guilty. The judge then says that, okay, I will hear arguments now on custody status. The defense lawyer always gets to go first. They read this long, or sometimes they do, they get to read this long dissertation that they generally give on, here's the 12 reasons why this person should be let out of custody while their case is pending. They say, they're not a flight risk. They're from here. They have a family here. Judge, the crime wasn't that bad. We're really making too big of a deal of this. He has no criminal history, or the criminal history he has, really is insignificant. They give all these reasons why the person should be let out. It is the job of the district attorney to make an argument based on public safety and flight risk. That doesn't mean in every single case we should be asking for the person to be held. Of course not. But what it means is we make an assessment. We look and see, right? Does John Smith have, a rap sheet as long as, my leg that says they've committed multiple violent crimes over and over again? Right, especially within the recent past. Is this a particular crime? The facts of the current crime, are they absolutely abhorrent and really concerning? Meaning, did they put a knife to somebody's throat and threaten to take their phone? Like, what are the facts? And you make that assessment and you say, okay, in this particular case, I believe you should remain in custody. Well, Chesa has issued a blanket policy that we cannot ask for cash bail at all. And I want people to understand, I am, again, in support of diminishing the use of cash bail. I think we need to be moving away from it, but we cannot eliminate it totally. And here's why. When you're in a universe of no cash bail, you have two options. It's release or it's detention without the opportunity to post bail. Detention without bail is reserved under the law, not Chesa Boudin, but under California state law, as for only those people who commit very serious and violent offenses or are a proven flight risk. So what really falls into that category are murders, rapes, child sex abuse, those kinds of things, very, very violent and assaults. But sort of everybody else doesn't fall into that category. We can't legally seek for them to be held without bail. And so if sometimes you have unique circumstances like the lady who was stealing from Target 128 times, right? Where she's not a violent offender, so she doesn't fall into that category. But we also are saying to ourselves, that seems like not the person that should necessarily be released tomorrow, right? After her case is charged. And Chesa won't allow the office the ability to use our discretion when we have situations like that, or maybe somebody who's committed now their fourth robbery, but it's not one that is particularly violent, but we're saying this is now your fourth robbery, right? You now have 4 open cases. Perhaps you shouldn't still be on the street. And so he's constrained the ability for his attorneys in court to ask for the judge to hold the person in custody. So the defense lawyer reads this long list of reasons why the person should be released. And then the assistant DA is either sitting on their hands, not allowed to say anything at all, and just saying, we submit to the court to decide, which generally signals to the court, okay, we're not allowed to say anything. Or they say, we submit to release, judge, and can you put an ankle monitor on the person? Well, we all know ankle monitors do nothing. And so he wants you to believe that it's only the judges doing this, but the judge is looking to the attorneys to make the argument. And the argument is not being made by the DA's office. And so when a judge is sitting there, especially the newer judges who are in these courtrooms, they're just hearing the laundry list of reasons why the defendant should be out, and the assistant DA agreeing to the release or not saying anything. And so they're saying, well, okay, if both sides agree he should be out, then I'll let him out.
And that's what I have to do. Right. I am going to, I have about 100 more questions for you, but we are like overtime now. So I'm going to say, anybody who wants to stick around for a few more minutes, we love to have you. This has been such a great discussion. I'm going to go to the questions, the people who have raised hands, and we might be able to also have a little bit of time to take a few things from the chat. But Jorge, I think you had your hand raised first, if you want to ask a question.
Yes, assuming that there will be a change, or we will vote for a change of a new DA, what should we expect in terms of change? I mean, what should be the number 1 or 2 critical components that we expect from a new DA to change, and how to change this the system as it is today?
Yeah, and that's a fair question. I think first, you need somebody that actually knows how to do the job. You've got to have somebody with experience who understands the nuances of being a prosecutor, and that doesn't take this one size fits all approach to prosecution, because it doesn't work. It doesn't work if it's in the punitive form, and it doesn't work if it's in the non-punitive form. Every single case and defendant have to be addressed for their individual circumstance. And that's what you need, is a DA who's willing to do that, who's willing to return discretion back to the DA's office and say, look, we want to be trending in a certain direction, but there are sometimes cases that present us with facts that don't fit into that framework. And we're not afraid to deal with those people on their individual basis. And so that would address, I think, a lot of the issues that we have now with repeat and chronic offenders being released back out onto the street within days. We need somebody that's not going to abuse these collaborative court and diversion programs, who's going to restore back to it the structure that it used to have. And I just want to explain really quickly that about 2/3 of the DA's office is now managed by former public defenders. One of whom was brought over to manage the collaborative court unit. That person did away completely with every single criteria that we had for how someone was eligible for these court programs and whether or not they could stay if they reoffended while they were out or didn't show up and do what they were supposed to do. And so they've been so watered down that they're actually no longer having any benefit to the offenders that are in them. And they're actually doing a disservice to our community, because these people are out in the community, and rather than getting treatment, most of them are reoffending. And so we need someone who's going to restore order back to that unit within the office, so that we can really take back control of the situation of who's being, out in the community. Oftentimes committing there's a small group of offenders sort of who are creating the most chaos, right? You may have seen a case of somebody who had committed 28 burglaries, residential burglaries. And so those are the people that they've got to be addressed after burglary number 1 or 2.
Thank you. I have, if you don't mind, one or two more quick questions. One, have you seen in your experience under Boudin, the office taking violent felonies and reducing them to misdemeanors?
What, can you say that one more time?
Have you seen in the office under Boudin them taking violent felonies and reducing them to misdemeanors in certain circumstances?
As far as pleas?
Well, like they'll charge it as a violent felony and then reduce it to a misdemeanor. I read something about that, and I'm wondering if that is true, or maybe you don't know anything about that. Maybe it happened.
Well, like I said, I gave the example of the case that was referred to diversion, the carjacking case. There are other cases. I think I wouldn't say necessarily the most violent cases. Sometimes what they're doing is allowing them to plead, if it's a robbery, they're allowing them to plead a robbery, but they're just putting them on probation with the few days credit for time served. So it may even show up as the appropriate charge on their record, but there's just no accountability for it. There's no consequence. And so that, really is no different than giving someone a misdemeanor. It has the effect because it's on their record, but for them in reality, right, when you're a 20-year-old and you're saying, well, I took a quick plea and I got out, right, or I was already out, and they're not making me do any programming, they're not making me, right, engage in anything or sending me to jail. To them, it's no different. Right.
Okay. And can you talk just for a second about the way that I feel most DAs that I've experienced in my lifetime in San Francisco or other places I've lived, I might not even have known who the DA was. Like, there's not been a lot of real sort of press or marketing or is this unusual, the amount of public speaking and sort of PR that Chesa does as a DA?
So it is more than what we've commonly seen. I mean, some people would attribute it to the fact that he's facing a recall. And so he's just garnering more attention that way. But Chesa appears to be a DA who really emphasizes having press conferences, even more than what I saw with George Gascon when he was in San Francisco. And one thing that I will note, in addition, not only to just doing the press conferences, but it's what underlies the reason for the press conference. And I've been told by other colleagues who have left the office that Chesa has in particularly tried to take credit for investigations and not allowed cooperation with the police for the sole purpose of not allowing the police to take any of the credit for these investigations. In the case of the woman stealing from Target, the loss prevention officer was instructed by an investigator from the DA's office not to call the police, actually, was instructed to call the DA's office when that woman came in to steal, just so that the DA's office could sort of take the credit for that investigation. And so this does appear to be a unique circumstance where he is trying very hard to garner a lot of media attention.
Thank you. Peter, you have your hand raised, and then we will wrap it up. Peter, if you're talking, you're on mute.
Appreciate it, and very much appreciate you, Brooke, and everything you've shared with us today. You've been terrific. And this is maybe a tough question. Maybe you can't, I'm not sure if you can answer this, but where does the line get drawn? Because I know you said you believe in reform. I believe in a certain amount of reform. But if someone breaks into a car, it's still a violent act. If someone comes out of their car and knocks someone, off their bicycle and beats them up, it's a violent act. If somebody breaks into somebody's home and robs them, that's a violent, act. So I guess I'm just asking, where do you feel the line is drawn as to accountability and actually putting people away and putting them in jail and versus letting them be free? And I know that's kind of a loaded, big question, but I'm just curious what your thoughts are there, because I respect you and your thoughts and opinion. Because I think for a lot of us who are seeing all this happen on the streets, it's like, where does the line get drawn? So anyway, that's a
fair question. It's one that as a prosecutor, you ask yourself every single day that you do this job, right? You look at a case file and you look at someone's criminal history and you say, in my view, when is enough enough? Right? Have we given you chances before? Have we offered you the ability to change your life before? Have you taken advantage of it or have you not? I've had defense lawyers say, well, this is their first offense. And that first offense is pointing a gun at somebody's head, pistol whipping them with it even, and stealing their purse, an elderly woman. And I say, I get it. It's their first offense, but they picked the biggest bull at the rodeo to ride. And so I'm stuck here, right? There has to be a consequence for that particular type of action. And so like I said, it's a question you wrestle with as a prosecutor day in and day out. And so that's why it's important to have a leader who has a vision for what those boundary lines are. Working for Gascon when he was here, he took violent crime very seriously, right? We had a lot of problems with auto burglary and those kinds of things, and those probably should have been addressed a little differently. But there was a line. And that doesn't mean that you simply say, okay, well, if you commit a robbery, you go to prison, because that's not always the answer either. I've given those second chances, right? And when I say second chance, that sometimes means a 2-year. I've even sent somebody who committed armed robbery to a 4-year residential program, not for drugs, but for literally just rehabilitating your life, where they could not leave for 4 years. Just like you can't leave jail, you could not leave there. And he had to wear an ankle monitor all 4 years. And that program, the second he walks out of that door early, who to call? Because some people when you talk to them and you flush it out, and we have people in the office capable of doing that, do understand the seriousness of what they did after they've had to sit for a while. And that gentleman had already been in jail for several years before we made that agreement. And they're saying, no, I want something different. And so I'm willing to do the work. But sadly, there's a lot of people that aren't. And so the line has to be violent crime, which there is a category actually in our statutes that denotes what is violent and what's nonviolent. And also chronic offenders. We have to be able to deal with them appropriately. We cannot let people, right, break into cars over and over and over again with no consequence. We can't let people burglarize stores with no consequence repeatedly. There has to be a line of demarcation. Drugs, that's another thing. You know, I handled a fair amount of drug cases in my time, and first offense, it's like, look, let's try to let this be your wake-up call. Don't come back here. If you come back here though, it'll be a different story. And when they come back again, you have to deal with them differently, right? If you condition them that the only response is going to be constant release and probation, they're just going to keep doing it. Yeah. And so that's the best answer I can give. There's no.
That's great. I appreciate I very much appreciate your response. That makes total sense. So thank you very much.
Yeah, I do too. Just the idea that it's an everyday thing that weighs on you, that you want to do the right thing in each specific situation. That's actually really helpful to hear. I am going to call it a night, even though I could ask you 100 more questions. Brooke, thank you so much for being here. I'm wishing that we had someone for you to debate. I was really looking forward to an actual debate, because I think that is the best way that we could come to clarity on what is really happening in our criminal justice system and what is really happening with the DA, and why this recall effort is happening, and why people are passionate on both sides. As Danielle from the League of Women Voters said, it's a hot button issue. So I was really looking forward to that, but I'm glad that we could, do a little research and bring in some of his points and have a discussion involving those points. I really appreciate you enlightening us and educating us. Thank you so much. Thank you to everyone who's attended. It is amazing. I think at one point we were up to like 98 people on here. So thank you all for coming, being interested and active, civically engaged. So grateful. And we will see what happens going forward. So thank you so much.
Thank you. Thank you for having me.
Absolutely. It's our pleasure. Good night, everybody.